Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. Please subscribe to our channel. You know, when we talk about divorce and custody, many times the discussion leads to divorce and custody modification. We want to change the judgment of divorce. We want to change the order of custody. What's involved in doing that? What do you got to know? Well, there's a few things you got to know. Number one, if you go to court and you stand before a judge and you raise your hand, and you go through the property settlement and you say, yes, I agree that this is fair. Yes, I agree to be bound by this. No, I'm not under any duress. Nobody's forcing me to do this. I'm agreeing to the settlement because I think it's in everybody's best interest and I want to, and I do so voluntarily. If you do that and you make the statement and the other side makes the same statement, and that's done in every divorce case when it's finalized, when that happens, if you later change your mind and say, I think I should have taken the house. I think I should have done this. I think I should have done that. I should have taken the car. I should have gotten the better car, the worse car. When you want to change your mind about the property division, be aware that the court is not likely to modify the judgment of divorce as it relates to the property provisions. I'm not talking about custody or something that's a child. I'm talking about stuff. When it comes to the property division, be it a house, a car, or whatever, the court is not likely to change what the parties already agreed to because the court has a strong interest in finality. You agree to it, it's not going to be modified. The only way to modify a judgment of divorce in that way is to prove that there was some fraud, some duress, something that went on which made the deal unfair. But it can't be because you've thought about it and you're having buyer's remorse. It's not going to cut it. You're going to have to show that somebody deliberately defrauded you. Very tough standard. When it comes to custody, that's a little different. The court will consider custody even if everybody agreed and it was fair. Last year, everybody thought mom should have custody of little Bill. That's fine. No problem. Nonetheless, if you can show that there's been a significant change in circumstances, the court will revisit custody. So for example, if you say to the judge, yes, it was fair to give mom custody last year, but since then she's become a drug addict and an alcoholic. It's not good for the child. I want custody review. The court will do it and may well find that a change is in order. If you say, yes, dad had custody and that was fine, but over the last year, the kid missed 82 days of school. He's failing out of all his classes. The court will say, you know what? We got this again. Yes, I gave an order last year, but I'm changing my mind, or I'm at least considering changing my mind. The court will do that. Notice the difference. There's much more finality with respect to stuff than there is with respect to people. When it comes time to the custody, the court is very, very careful to make sure that the appropriate environment is maintained. Those are considerations not necessarily in play when we're talking about property. So if you have any questions about your case, reach out. We'll be glad to help you.